you're contemplating getting a divorce anywhere in the state of Florida, it's very important that after you speak to your family law attorney, that you speak to an estate planning attorney, because the effect of filing for divorce, for initiating the dissolution of marriage proceeding, has a significant impact on your estate planning. And once that proceeding is finalized, once the dissolution of marriage is officially done and over with, it has another impact on different aspects of your estate plan. So for example, your power of attorney, upon the initiation of the proceedings, meaning the divorce doesn't need to be finalized, the process just needs to be started. If your spouse is listed as your first primary power of attorney, their ability to act on your behalf immediately ceases. Okay, well, that can be a good thing or that can be a bad thing, and we also have to figure out whether or not third parties know it, because if they're still walking around with your durable power of attorney, the bank might not know that a dissolution of marriage action has been filed, right? So not only does the impact significant, but you want to make sure that you have adjusted your documents and amended your documents to provide for that. Now, interestingly, their ability to continue acting as your healthcare surrogate does not automatically go away upon the initiation of your divorce. However, once the divorce is finalized, if you've named your spouse as the primary healthcare surrogate to make healthcare decisions for you, then their power will disappear automatically. Again, you're going to want to redo these documents because you want to get them in the hands of the third party to prevent the ex-spouse or the soon-to-be ex-spouse from being able to make decisions on your behalf. Interestingly, with your trust and with your will, if you have a revocable living trust or you have a last will and testament, it's only after the dissolution of marriage has been completed are they presumed, or the impact is those documents, if they haven't been amended, is they'll be treated as if your ex-spouse has predeceased you. So whatever the documents has happened in that situation, that's what will happen with the administration of your trust or the execution of your will, the administration of your will in the probate court context if you are going through probate. So with your healthcare surrogate, your last will and testament, and your trust, only after the proceeding has been completed, only after you're officially divorced is your ex-spouse officially cut out. Only with the power of attorney does it happen automatically upon the initiation, upon the commencement of those proceedings. So again, you want to have these documents taken care of before you actually get divorced, because you may not want to wait for the divorce to be finalized before you disinherit this spouse, right? Because God forbid something happens while the proceeding is going forward, your soon-to-be ex may get a windfall that you don't want them to get. Now, if you want them to get it, that's perfectly fine. And in fact, some of these documents, we occasionally have people getting divorced who they want their former spouse to continue acting as their healthcare surrogate or their power of attorney, because while the marriage didn't work out, they're still close friends, they still trust each other, and that's okay. We want that to be contemplated in the actual documents themselves, that even if I get divorced, I still want this person to serve as my key decision maker, or I still want this person to inherit from me. That's okay, but you want to make sure you're going into this cognizant of what's going to happen, not only when you initiate the divorce proceeding, but after it's been finalized. So if you're a family law attorney who has clients going through a divorce, you may want to send them to, if it's not our office, an estate planning attorney that you have a relationship with. And if you are the one commencing the proceeding, again, if you have an existing estate planning attorney, you can go back to that person. That'll probably be the most economical way of amending these documents. And certainly if you don't and you're anywhere in the state of Florida, we're happy to talk to you in our office as well. Thank you for watching.